Mr. Chairman, Chairman Willard, members of the committee, my name is Lee McGrath. I'm the Legislative Counsel for the Institute for Justice. The Institute for Justice is a not-for-profit public interest law firm. We have litigated and lobbied the issue of forfeiture across the country. Our firm is best known for a case that we lost at the United States Supreme Court, Kelo versus City of New London. That was an eminent domain case regarding the powers of the Connecticut city to take someone's private property. Well, we look at forfeiture through the same lens that we look at eminent domain. When can the government take your property, and what process do you get? And in both eminent domain and forfeiture, we believe that the process should be significant and the government's taking powers should be narrow. I appreciate the effort that has gone into this effort. It's a difficult assignment. Georgia has some of the worst forfeiture laws in the country, and the very worst in the South. So I appreciate the hard work that Chairman Willard and others have put into it. Unfortunately, we were not part of that stakeholders. No one representing property owners or the criminal defense bar was part of that stakeholders meetings that occurred over the summer, and so we're particularly appreciative of the opportunity to testify today. Moreover, Chairman Willard has been friendly to our initiatives, and I look forward to working with him in the future as we move from what I perceive as a rather modest bill that improves reporting but does not get at the substantive issues that are inherent when you have a two-track system of criminal prosecution for the person and civil prosecution for the property, as if somehow the property were guilty or liable for some crime independent of the guilt or innocence of the person. Additionally, this bill leaves for another day the corrosive effects of money going to supplement the budget of prosecutors and law enforcement agencies. So I'm anxious to continue the discussions with the chairman and with this committee in the future. For today, I would like to focus on just three very, very narrow issues that I think are in the spirit of supporting this legislation, but improving it. I hope this legislation is enacted, and I hope some of these minor changes are included, both the ones that I offer as well as my colleague from the ACLU, Chad Rock. The first is regarding reporting. It is my contention that no one in the state of Georgia should lose their property if they are not charged or they are acquitted of a crime. You should know as legislators to what extent people who are found innocent or not charged in the criminal process still lose their property because of the lower burdens of proof in the civil context. I would prefer to have one process, but that is not on the table today. Today, someone can be found innocent in Georgia of a crime, but still lose their car, still lose their cash, because their cash is found liable, or their car is found liable at a lower standard of proof without any of the constitutional protections inherent in the criminal process. So I would ask the committee to amend line 794 of the bill to include, in addition to, in the reporting requirements, the name, the 793 reads, the name of any alleged crime and applicable code section that caused the seizure of the property. This is very important to the committee, but equally important would be that the report tells legislators the outcome of the related criminal action, including whether no charges were brought, a conviction was obtained, or an acquittal was issued. And I'm happy to give copies to the members at any time as a way of better knowing in the future to see the problem at hand by having two processes, one beyond a reasonable doubt, one preponderance of the evidence. So, Mr. Chairman, I would offer that as something for the committee to work with the committee as a way of, in the spirit of a very good reporting bill, making it even better. Moving on to just my second point, an A and a B, deals with innocent owners. Innocent owners are people who are not charged with a crime. They are people who are not charged, are not convicted, but have their property seized, perhaps because it was used by someone else. In this bill, the innocent owner has the burden of proving that he didn't or she didn't have knowledge. This is an important area. These are the wives and mothers and grandmothers in Georgia who should be able to go into court and get their property back. The bill puts the burden on the government to show that puts the burden on the owner, the claimant, the wife, the mother, the grandmother, to show she did not have knowledge. I ask you to turn to section 557, line 557, Mr. Chairman, members. And here on line 57, starting on line 553, the property shall not be subject under this chapter if the owner or interest holder establishes that the owner or interest holder, and then line 557C, did not know the conduct giving rise to the forfeiture. This is a valid test. Fine. The person has to prove she didn't, the mother, the wife, didn't know. But the bill goes on, and I'd ask you to consider that it goes on to 558, and this is somewhat redundant, did not know the conduct giving a rise to the forfeiture was likely to incur. But in particular, I'd ask the committee to consider deleting 559 and line 560. That the wife, the mother, the grandmother would have to go into court and show that she should not have reasonably known that the conduct giving rise to the forfeiture was likely to occur. What this line does, Mr. Chairman, members, is to engage the court into a bizarre negligence test. Should that wife have asked enough questions? Should that mother have hidden the keys to the car? Should that grandmother try to stop the grandson from taking the car? And if the judge finds through some sense of what a reasonable mother is, or a reasonable wife is, or a reasonable grandmother is, he should then deny that claimant the car back. This test is very problematic and partially redundant, Mr. Chairman, to what is already on 557. I think it would be, in order to get cars and cash back to spouses, it would be good to delete 559. Similarly, Mr. Chairman, and this is my last, I know I'm in the weeds here with you, but this is my last point. And it is on line 564 through 566. What this section says is that in respect to a vehicle, a conveyance for transportation, the innocent owner person, the wife, the grandmother, the mother, did not hold the property jointly, in common, or in community with a person whose conduct gave rise to the forfeiture. In other words, what this section says is that Mrs. McGrath, Mrs. Willard, Mrs. Jacobs doesn't even get her day in court. If the vehicle in question is titled jointly, she can't even come to begin to argue that she didn't have the requisite knowledge. The doors of the courthouse are locked to her. I submit to you, Mr. Chairman, that this is a very serious due process. When you deny people even the opportunity to go through the very difficult process of filing the paperwork, responding to a complaint, you lock the doors to those claims, you've presented a huge, an issue of due process that should give the committee great concern, and I would encourage the committee to delete 564 and 566 and let every spouse who is jointly on title with the suspect have her day in court. With those deep down dives into a good but modest reporting bill that does good things in terms of give future legislators information about this very problematic area of law, I stand for your questions, and thank you.
Mr. Brock, did you have anything to add to that?
Thank you, Mr. Chairman and members of the committee. My name is Chad Brock. I'm staff attorney and legislative counsel for the ACLU of Georgia. The ACLU's core concerns with our forfeiture system are the accountability, transparency, which we think have been mostly addressed with this bill, and also our concerns involving the due process rights of property owners. We have represented individuals who have come before the ACLU who have had their property seized without being charged with a crime, which does also explain our position that we would like to move toward a criminal forfeiture system. As Mr. McGrath articulated, those owners in that system would be given greater constitutional protections than is currently provided in the civil system. That being said, we do have particular concerns with individuals who are coming forward and either cannot afford an attorney or cannot find an attorney who would be willing to represent them when there's an insignificant amount of money involved. So we appreciate the inclusion of some language here in 916.11 under the non-judicial forfeiture procedures, beginning in section C3. If any claim is served, even when the state attorney determines that the information provided by the claimant pursuant to paragraph 2 of this subsection is insufficient, the state attorney shall file a complaint for forfeiture as provided in code sections 916.12 and 916.13. We think that is a good step, but we think that we could add some language to give full effect to the purpose behind that, and also give effect to the Special Counsel of Criminal Justice Reform's recommendation under Recommendation 3 by beginning that line with any claim made by an owner or interest holder shall be entitled to a determination on the merits. And that language is essentially taken verbatim from the Special Counsel of Criminal Justice Reform's Recommendation 3 and their latest report. We just think the inclusion of that language would strengthen it and ensure that these owners, particularly these pro se claimants who are coming forward to claim a relatively small amount of money, do at least have their day in court.
All right, questions for Mr. McGrath or Mr. Brock? I'll turn Mr. Weldon's light on. Anyone else? Seeing none, thank you for your testimony.
Thank you very much, Mr. Chairman.
I do have a statement that I was authorized to make by David Poitras, who could not be here today, with Common Cause. Would it be appropriate to make that brief statement?
Sure, that's fine.
Thank you. So David Poitras is the policy board chair of Common Cause, and they are generally supportive of House Bill 1. The statement reads, "The central idea of Common Cause Georgia's position on civil forfeiture is that law enforcement agencies should not be able to manipulate the complexity and cost of the civil justice system to impose a form of extrajudicial punishment on private citizens while at the same time enriching the coffers of the agency for which they work.
All right.
Mr. Chairman, Julie Thompson of the Tea Party Patriots of Atlanta has asked me to make a statement on her behalf. May I do that at this time?
You certainly may. She was signed up to speak. I guess
She had to leave for
kind of like I do.
parental reasons.
All right.
Mr. Chairman.
No, not like I do. Much more important. Go ahead.
Thank you, Mr. Chairman. Ms. Thompson of the Tea Party Patriots writes, Chairman Jacobs and members of the committee, on behalf of the Atlanta Tea Party and on behalf of the Capital Coalition of Conservative Leaders, which is made up of 39 leaders of Georgia's major conservative political grassroots organization, I thank you for your work on this bill and Representative Willard for all of his efforts. While we all appreciate the part of the bill that deals with reporting and cleaning up that procedure, we have great concerns, she writes, with other areas of the law that need to be corrected. We fully agree with Mr. McGrath and Mr. Brock, and we ask you to take the opportunity to recognize the opportunity before you to truly represent the rights, the property rights, the due process rights of the citizens of Georgia. Signed, Julie Thompson, Chairman, Atlanta Tea Party, co-founder, Capital Coalition of Conservative Leaders. Mr. Chairman, thank you.
All right. Thank you, Mr. McGrath.
Thank you.
And you usually travel to join us, correct?
Yes, I thank you for such warm weather. It's 10 degrees warmer here today in Atlanta than it was in Minneapolis when I took off this morning at 6:30.
It's all relative.
So I
isn't it?
appreciate your kindness and concern.
Absolutely.
So, thank you.
Mr.
Thank
McGrath.
you.